Weiss+Associates presents Taxing Income of U.S. Citizens Abroad. There's a plethora of discussion, most of which is based entirely on presumption that the federal income tax was created to tax U.S. citizens wherever they earn their living in the world. An important aspect of this discussion is centered on the proper understanding of exactly what's meant by the expression U.S. citizen. At first glance, many people have a puzzled look on their face, which is reflective of many American nationals having little to no awareness that there are two separate definitions for this phrase. You must be diligent to make certain that you don't fail to differentiate the distinction by the use of this expression. Since we already have a YouTube video on Are You a U.S. Citizen, we'll not linger on this subject. A link to that video appears in the show notes below. It's important to note that the national government has a statutory definition that can best be understood at 3C Amjur 2D Section 2689, who is born in the United States and subject to its jurisdiction. The national government, based in the District of Columbia, only refers to the statutory expression of this term U.S. citizen in regard to its federal income tax scheme and the 16th Amendment. The U.S. Constitution uses an entirely different definition for the meaning of this expression, and we refer to it differently in order to avoid confusion by the expression American national. This term is a non-statutory one that we felt was a way to keep the confusion to a minimum. For clarity, an American national as we refer to this term means one who was born in the constitutional republic, the 50 states of the Union, or one who was naturalized therein. The issue of jurisdiction once again takes a dominant role in understanding what's being said and how the national government uses their definition to influence the world banking system in its effort to spread the fictitious message that all Americans are U.S. citizens without defining the terms. Generalized terms are frivolous as they're based on propaganda efforts to scare international bankers from dealing with those who think that Americans, born in the 50 states of the Union, are statutory U.S. citizens and equating them as statutory U.S. taxpayers. This confusion started in the Supreme Court case Cook v. Tate, Collector of Internal Revenue, in which a Mr. Cook, a native citizen of the United States who lived in Mexico and built yachts there, was being targeted by the IRS. The court didn't clarify exactly as to the meaning of native citizen, but when you read the definition in Black's Law Dictionary, you find stated in part, a natural-born subject or citizen by birth who owes his domicile or citizenship to the fact of his birth. The expression subject in Black's shows that it means one who owes allegiance to a sovereign and is governed by his laws. American nationals are not subject to the national government, and thus, that government is not sovereign over American nationals. In the 1886 case Yick-Wo v. Hopkins, we learned that American nationals are the sovereigns, and the national government is the servant of we the people. Only a few of the God-given rights were designated for the use by the national government, things like national defense, establishment of treaties with foreign governments, and a few others. The Supreme Court decision in Yick-Wo v. Hopkins stated in part, when we consider the nature and the theory of our institutions of government, the principles upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts, and the law is the definition and limitation of power. Thus, the expression native citizen referenced by the Supreme Court can only mean those statutory U.S. citizens born in U.S. territories who by their birth are subject to the dominion and control of the U.S. Congress, the monarch over them. Mr. Cook, likely unbeknownst to him, was thus understood to be a statutory U.S. citizen, not an American national. Per the legislative intent of the 16th Amendment and the wording of the 16th Amendment, in which the rule of apportionment was intentionally omitted by the U.S. Congress, the federal income tax was indeed applicable toward him by birth in a U.S. territory, but the actual territory was not provided. It's at this point the U.S. Congress made it clear to the Supreme Court that the court was dealing with a statutory U.S. citizen, one born in one of the U.S. territories or the District of Columbia. Then in Cook v. Tate, we see, it will be observed that the foundation of the assignments is the fact that the citizen receiving the income and the property of which it is the product are outside of the territorial limits of the United States. Or to put the contention another way, to the existence of the power and its exercise, the person receiving the income and the property that receives it must both be within the territorial limits of the United States to be within the taxing power of the United States. It was further stated in part, and that power in its scope and extent, it was decided, is based on the presumption that government by its very nature benefits the citizen and his property wherever found. Or to express it another way, the basis of the power to tax was not and cannot be made dependent upon the situs of the property in all cases, it being in or out of the United States, nor was not and cannot be made dependent upon the domicile of the citizen, that being in or out of the United States, but upon his relation as citizen to the United States and the relation of the latter to him as citizen. The reference is to territorial U.S. citizenship only, and can only be that due to the Supreme Court's Pollock decision in 1895 about the obligation placed upon the national government by the U.S. Constitution in Article 1, Sections 2 and 9. This is significant to the proper understanding of the jurisdictional limitations imposed against the U.S. Congress to stop the attempt to defraud the true status of those who are American nationals by birth in the constitutional republic, the 50 states of the Union. Then, Cook v. Tate continued with, the consequence of the relations is that the native citizen who is taxed may have domicile, and the property from which his income is derived may have situs in a foreign country, and the tax be legal, the government having the power to impose the tax. Hopefully, you see the well-established distinction made by the Supreme Court in the Pollock decision. The U.S. Constitution never granted the national government a power or authority to impose a federal income tax upon American nationals directly, unless such was done via the rule of apportionment. So, we finally see that the national government, located in the District of Columbia, has jurisdictional authority only over those who are born within their territorial jurisdiction, no matter where their property or subjects might wander off in the world. Statutory U.S. citizens are not able to expatriate and leave the confines and control of the national government, except on those rare occasions where such former U.S. territories, like Cuba and the Philippines, were granted independence. Those American nationals born in the constitutional republic are unique in that the national government is not the sovereign over those born within the geographical jurisdiction of the constitutional republic. To ignore these facts would make the U.S. Constitution null and void and expose the fact that some kind of coup d'etat has taken place in silence via manipulation of words that leave American nationals as slaves of the national government and no longer the sovereigns, as stated in Yickwo v. Hopkins. Only those statutory U.S. citizens are so constrained. Those statutory U.S. citizens must file and pay the federal income tax every year per the 16th Amendment, as they're not protected by the U.S. Constitution and the requirement imposed upon the national government by the Founding Fathers, who originated the foundational document that American nationals presumed to live and prosper by. Politicians, since the founding of the Republic, have created laws or attempted to create laws with purposeful vagueness to gain control over the people's lives. The laws today don't provide the definition of the terms it refers to for American nationals and others in foreign countries to easily comprehend what the meaning of the terminology actually is addressing. This is willful disregard for the well-being of American nationals who elect to live and work in a foreign country or foreign jurisdiction, vis-a-vis that of the Territorial United States in the creation of FATCA, the Foreign Account Tax Compliance Act. This fraudulent act, signed by treaty with foreign countries, illustrates the utter disregard for clarity in law and has caused confusion resulting in incorrect presumptions by foreign governments and international bankers. To date, the national government has succeeded in instituting false presumptions against American nationals who are not and never should have been made a target. Definitions of terms and expressions are important. The willful and intentional lack of clarity on the part of the national government is evidence of a government which has abused or threatened abuse of law or legal process, which has resulted in serious harm being directed toward American nationals who are neither of the subject nor of the object of the revenue laws that it portrays to foreign governments and international bankers. The national government is not the sovereign power it pretends to be in regard to American nationals and the question of federal income taxation on the income derived worldwide by American nationals. The only jurisdiction to which the Internal Revenue Code is lawful within is the territorial jurisdiction referred to as the District of Columbia and its U.S. territories. You can denote what jurisdiction the politicians are addressing by the expression they elect to use to represent the territory of the national government when they state the democracy. It's a euphemism for this territorial jurisdiction where the IRC is only applicable within. In stark contrast, the Constitution was established to segregate the national government's jurisdiction from that of the states of the Union. This is what is meant by the expression constitutional republic. Hopefully, you remember what the constitutional republic refers to. It's the one which notes were first published in the American Historical Review regarding a founding father's comment, and the anecdote on page 618 reads, "A lady asked Dr. Franklin, 'Well, doctor, what have we got, a republic or a monarchy?' 'A republic,' replied Benjamin Franklin, 'if you can keep it.'" This is the jurisdiction to which you pledge allegiance, to the republic for which it stands, not to the democracy. The erosion of years of efforts by the political class has penetrated the minds of American nationals by repeating their propaganda for the purpose of converting the constitutional republic into a socialistic democracy ruled by an elite class. It's the responsibility of each American national to keep the government, your servants, from falling into error. Income taxation from worldwide investing and banking by American nationals has been impacted by FATCA, and American nationals have been falsely viewed as criminals and tax cheats via the propaganda efforts of the national government. So, we pose this question to you. Does the constitutional republic still exist, or is it a Walt Disney World illusion? If you live in a foreign country and find yourself in the predicament of having to unjustly deal with this onerous FATCA legislation, perhaps we can help. Please email us at bilateral@gmx.com. Also, check out the Resource Center at our website, Weiss+Paris.com, where we have links to many other educational videos. Please give this video a like if you found it informative, share with your like-minded friends, and subscribe to our channel. Thanks for watching.